Buying a house is more than just picking the right place. It's about nailing the details that can make or break your experience. Sure, we all know that checking for a sturdy roof or a working cooling system, but what about the nitty-gritty legal stuff? You know, like force majeure. Clauses that could throw your plans out the window, or the sneaky bits like prorations and special assessments. This video is all about those 6 crucial but easy to miss parts of real estate contracts that can burn you if you're not aware. And you know what? Sometimes even top-notch real estate agents might miss pointing these things out, and lower-notch agents too. It's not always obvious at first why they're important, but trust me, you don't want to learn the hard way that these details matter. So let's dive in and uncover these hidden gems together. It's all about staying one step ahead and making sure your dream home doesn't turn into a legal headache after you get the keys. What the heck is force majeure in real estate? Force majeure in real estate contracts refers to extraordinary events or circumstances beyond the control of the parties involved, such as natural disasters like earthquakes or hurricanes, war, strikes, or acts of government. These events are considered unforeseeable and unavoidable. When a force majeure clause is included in a real estate contract, it typically excuses one or both parties from fulfilling their contractual obligations when such events occur. For instance, if a major storm drops a tree on a home the day before closing, it will impact the terms of the contract. The force majeure clause might allow the seller to extend the deadline without facing penalties or delay so that the house can be returned to its pre-storm condition. The specific applications and consequences of a force majeure event can vary based on the wording of the contract and the legal context in which it is interpreted. If you're a longtime subscriber, then you know I often discuss the home selling process because I often see sellers and buyers leave money on the table because they, or their agent, were unprepared for the subtleties embedded in the real estate contract. If you're not a subscriber, please click the thumbs up like button and subscribe now so that you get all my new content when it is fresh. If you really want to know what's going on in housing, to see and hear the data explained, to evaluate the facts, and ignore the hype that's so prevalent online, then subscribe now and I'll keep you in the know. In a real estate contract, the terms closing and possession refer to 2 distinct but related aspects of the property transfer process. Closing. This is the final step in the real estate sale where the buyer officially becomes the property's owner. It involves signing documents, paying the purchase price, and handling fees. Once paperwork is finalized and payments made, the sale is complete. Possession. This is when the buyer gets to move into the property. It typically occurs immediately after closing, but the contract might specify a different time. The exact terms of possession depend on the agreement between the buyer and seller. The specific terms regarding closing and possession are crucial in a real estate contract and can vary greatly depending on the agreement between the buyer and seller. These terms should be clearly defined in the contract to avoid any misunderstanding or disputes. Make sure your real estate agent briefs you on closing and possession before you sign an offer or contract. You'll need to know when you must be in or out of the home. In a real estate contract, prorations refer to the process of dividing ongoing expenses related to the property between the buyer and the seller based upon the period each party is in possession of the property. These expenses can include property taxes, utility bills, homeowners association fees, insurance premiums, and other local expenses. The purpose of the prorations is to ensure that each party pays only for the expenses incurred during the time they actually own the property. For example, if a seller has paid property taxes for the entire year but sells the property on the final day of November, the buyer would be responsible for the prorated share of those taxes, covering the month of December when they own the property. The exact details of how prorations are calculated and handled are typically specified in the real estate contract and are often settled at closing. This ensures a fair distribution of costs and prevents either party from paying more than their share of expenses for the time they own the property, unless, of course, something is overlooked by either party. A special assessment lien in real estate refers to a charge imposed on a property for public improvements that enhance the value of the property, such as road construction or neighborhood beautification. It's crucial for both buyers and sellers to understand special assessments before executing a real estate contract. These liens are distinct from regular taxes as they are attached to the property itself, not the owner. This means the lien remains with the property if the property is sold. Special assessments can be paid in full or in installments, depending upon the term set by the authority imposing the assessment. A common example is when a neighborhood transitions from individual septic systems to a public sewer system. The local authority charges each home a special assessment for the sewer connection, often spread over time to ease the financial burden. The situation gets interesting when a property is sold during the term of a special assessment repayment, as the buyer will soon take over the payments. Sellers must disclose any existing liens to potential buyers, as failure to do so can lead to legal issues. Buyers, on their part, should investigate any liens on a property before purchasing, as they can impact the property's value and attractiveness. The sales contract should clearly outline what liens exist and who is responsible for paying those liens, the buyer or the seller. You don't want to be a buyer finding out after closing that your monthly payment is higher than you were briefed because an existing special assessment lien exists on the property. And you don't want to be the seller in this situation either, as you could be sued and end up having to reimburse the buyer, or worse. Understanding special assessment liens is crucial, as they can significantly affect the cost of buying or selling property, and misunderstandings can complicate the transaction process. Here's something buyers often don't realize. There might be a lease you don't know about, whether written down or just verbally agreed upon. The contract should specifically ask about any existing leases. This is super crucial because as a buyer, you might not be aware of a tenant secretly renting the place. The contract language should be clear. It needs to find out about any leases, oral or written. Why is this important? Well, if you buy a house and, surprise, there's a tenant living there, you're now the landlord, whether you plan to be or not. The existing lease doesn't just vanish because the house is sold. You're stuck with it until it ends. Can you imagine planning on moving into your new home only to discover somebody else, through a lease, has all the right to use your property for another 6 months? Or even 6 years. Your purchase agreement should include language addressing an estoppel letter or estoppel certificate. This is a tenant's confirmation of their lease details. Getting the seller to sign one of these estoppel letters is a good idea, even if you don't think there's any leases on the property. Think of this letter as a safety net. It protects you from any surprises about leases that might pop up after you close on the home. We once discovered a listing by a property manager that failed to include the fact that the tenant had a valid lease for an extended period of time, though the tenant had not yet occupied the property. It would have been easy to see the home and assume that it was vacant and unleased, but that would have been a tough situation for our buyer had we not pursued an estoppel from the seller. The contract should also include details on security deposits and how rents get split at closing. This ensures you're not losing out on any money that's rightfully yours. In a residential real estate contract, you should address homeowners associations, or HOAs, and restrictive covenants. HOAs enforce rules, often outlined in restrictive covenants, that regulate various aspects of property use. These covenants cover aesthetics like home colors and restrictions such as renting out your home or operating a business from it. Restrictive covenants may also limit the types of pets you can have and specify maintenance requirements. It's crucial to review these covenants before purchasing. They're legally binding, and violations can result in fines or legal actions. Can you imagine discovering, after moving in, that your neighborhood does not allow dogs like the one you own? The law requires you to discover this before buying the home. These covenants may appear restrictive, but they serve important purposes. They help maintain property values, ensure community uniformity, and prevent resident conflicts. HOAs play a pivotal role in planned communities and condoic complexes. They establish and enforce rules, often documented in restrictive covenants, to maintain the community's integrity and functionality. Violating these covenants can result in penalties or legal actions, making compliance essential. While some may find these restrictions limiting, knowing them before committing to buying and being regulated by them is important. Understanding and adhering to HOA restrictive covenants is paramount when entering a residential real estate contract, so pay close attention to see what you're signing up for. Paying attention to these often overlooked details in your real estate contract can save you from future headaches and unexpected problems. Remember, knowledge is power, especially if you have not selected your real estate agent carefully. So take charge, ask questions, and don't hesitate to seek professional advice if you're unsure about anything. Before signing on the dotted line, ensure you're fully informed and comfortable with every aspect of your agreement. And now, it's your turn to take the next step. If you're getting ready to move, contact us at the link below the video. Let us know where you're moving to and from, and we'll help you choose the best agent to care for your needs. Empower yourself with the right agent, an expert in real estate contracts, and confidently move forward in your property journey. If you want to see a video featuring my 9 tips for buying a home in a highly competitive market, you can view it by clicking on the box on the left side of your screen. To see a popular video featuring my top 6 home selling tips, just click on the box to the right. Please remember to like this video, check out the links below it, and subscribe to our channel so that you never miss anything.